Aya, so hiyo ni hii inakuja come up September 18th, Iungo 19th. Oh. Kwani kuna hii Iungo ni 19th October wewe? Hizi Iungo mpya?
Iungo mpya ni
Good afternoon, everyone.
Good afternoon. My name is Wendy Muganda from the LSK Nairobi branch secretariat. We could give guys maybe just 2 more minutes and then we can start. Thank you. So thank you everyone for attending this webinar. Thank you to our speaker, Senior David Nyakundi. And for those who are not aware, we had the first session, and the session was chaired by Senior Calvin Nyachoti. And you can find the recording on YouTube, our YouTube channel. So just look for LSK Nairobi branch. So we are continuing with this series on pension practice. And our speaker for today is a partner at Simba and Simba and heads the pension law division under the corporate commercial department. So he's done a range of pension matters and dealt with pension service providers, litigation of pension suits. So we are quite excited that he's going to share some insights with us on the pension practice in Kenya. So Mr. David Nyakundi, the floor is yours. I think we can start. We have enough number of members attending.
Thank you so much, colleagues, this afternoon. I'm delighted to make a presentation, even as my presentation is loading. I hope you can see, just see whether everything is fine. Just a minute.
We can see your screen.
You can see the screen?
Yes.
I'm not sure why it is not. Okay, it's okay now?
Yes, I
Very
can
well.
still see screen. Yes.
I just want to see whether it's gonna move. If it doesn't move, we have slight difficulties.
Okay, sure. So in the meantime, I can see our chair has joined. So maybe chair can give a few remarks. Though I'd already welcomed everyone to the meeting, but it would be nice to hear from the chair. Chair?
Thank you, Wendy. Let me apologize for joining in late. Good afternoon, everybody, colleagues, friends, Mawakili, and welcome to part 2 of our series on pension management, understanding what pension management is about. How can we as advocates take advantage of this opportunity that lies there in pension management? I'm sure that most of us, when we think about pension, we just think about us saving for our pension. But I'm sure, as we shall hear from Senior David Nyakundi, there are opportunities for us as advocates. It's an area of law that we also need to consider to pursue in terms of advising our clients who are pension fund holders and other areas of this particular field. So, as Wendy said, my name is Helen Namisi. I'm the chair of the branch, and I want to welcome you quite warmly to this particular webinar this afternoon, and also look out for the next session that we shall be having very soon. We'll be sharing all that information on our social media handles, in our newsletter, and on email. With that, I want to hand it back to Senior so that he can proceed with his presentation. Asanteni sana.
I think I have a problem with my my configuration at the laptop. I don't know why it is not doing the presentation and moving it down. You can see the first screen, but the first slide was not moving to the next. Nonetheless, I can still do the presentation. Are you hearing me? You're hearing me?
Yes, we can.
Thank you so much. So first, thank you so much, Nairobi Law Society branch, for this privilege. Thank you, Helen, for. I also want to thank my friend Calvin Nyachoti, who started this series a month ago, and Stella Ojango, who has been pushing me to do this for a while now. And we are here, and think I want to encourage you to look forward for the next presentation, even as we do this one today. So what I'm gonna do, I'm gonna discuss with you some of my experiences and some of the areas that we need to pay attention to as lawyers, which are emerging areas, for purposes of practicing pensions in this market. To put this screen on, if you can give me a minute, just again to try. All right, let's proceed. I think there are still some challenges. So I'm cover a brief introduction on this area of practice. I give a brief definition of what a pension scheme is and the challenges of how we need to pigeonhole pension, and some of the legal forms and types of pension schemes that we have in the market and how the law fits into that. Then we shall be looking at the areas of practice in as far as pension is concerned. Then something about what is the qualification, or what should a young lawyer be preparing himself to be for purposes of practicing pensions in this market? And I get this question quite a number of times from young lawyers, and they ask me, how can I be a pension lawyer? Well, I'll give you some brief highlight towards the end of this presentation. So let me start with a brief introduction. I don't know whether you are seeing my screen now on introduction. Are you seeing my presentation?
Not yet, but
Okay.
okay, now it's loading. Yes, we can.
You can?
Yes.
Let's see whether it moves. Yes, that's fine. I have to get some more technical young lawyers here to help me. So we can proceed now. Thank you so much. So as a way of introduction, pension law does involve basically long-term management of large sums of money. And our participation in this area, which also transcends to matters finance, investments, matters insurance, our role is basically on the establishment, creation, of course, the structuring of a pension fund, and how we comply with various investment obligations which come along with pension funds, especially in the market, and of course, applies to many other countries which have seen and they provide us in this sector. This also includes some of the areas we need to deal with. Areas that we get involved in. In Anglo-Saxon countries, pension schemes are created as trusts, and they're highly regulated by various laws, a complex legal framework, which keeps changing every other year. So pension lawyers typically advise governments, we advise employers, members, trustees of pension funds, and very many other service providers who give specific services to pension funds in this market. Now, the other area which probably is critical, which I'll be briefly talking about, is pension lawyers do get involved in various pension reforms in many other countries, including writing national laws on pensions, which is a very interesting area. A pension scheme is basically a device intended to provide a mechanism through which people save a portion of their earnings during the economically active years into which during any country. And they are work-based. They assume that most people who will be working basically unfunded pension plans and paid out from tax revenues from government to the people who are needy. Or we do have some institutions, depending on the law of those countries, where corporations pay pensions from their general income, and they don't have to set any funds aside for purposes of paying pensions. They simply budget like any other cost is budgeted for, and out of that they pay pensions. Before 1997 in this country, that's how most of the parastatals were operating. Just like the closed civil service pension fund, they don't have money set aside. They just pay pensions from the general tax revenues to retired civil servants. Some are paid out of cash. Some are paid out as cash transfers, what sometimes we call in this market inua jamii, to the vulnerable members of society upon attaining a particular age. In this country, you need to attain age 60 and identified as needy by the chief where you stay, and then you qualify to get some 2,000 shillings from government. Pension law is, if you want to pigeonhole it, where does it belong? Is always an interesting question among many pension lawyers across the globe. Where do you allocate pension law? Now, pension law is fascinating. It's an emerging area of law, and there are always difficulties to determine where you place it. As a social issue, pension is impacted by aging populations. In Europe and many other Western countries, it is a social question which needs to be addressed by national policies. And therefore, reforms are triggered by this issue in more developed countries. But from a legal point of view, it is always hard to pigeonhole it. Where does it belong? I'm not too sure, not clearly identified yet. And it's because it is multi-pronged. You'll see aspects of pensions emerging in various areas where you practice as a lawyer. It's not well established as it is an emerging area of law, and because it is yet to be fully established into it, especially in our jurisdiction, the area of pension law in this country. There are a few cases that have been determined around benefits, but on the question of pension law as a subject, you don't get those kind of jurisprudence. Pension law is an intersection of many other areas of law which you'll come across. For example, constitutional law, the obligation of state to provide social security to the people who are needy, who cannot support themselves, is clearly provided for in Article 43 of the Constitution. If you look at pensions have been established by employers for their workers, and therefore you need to see whether it's an employment benefit question, is it a contract question, and of course there are many other wide range of statutory obligations which relate to pensions, which any good pension lawyer need to understand for you to give better legal advice to your various clients. And of course, you will be exposed to a lot of finance and investments in this area, and you need to understand investment laws which apply to pension funds. An area which I've been thinking through lately is whether family law has an aspect which has got to do with pensions, especially the Matrimonial Property Act. The definition of what is matrimonial property, I think in Section 6 of that Act, is not so straight to inform you whether accrued pensions during is part of what I call matrimonial property. And we shall look at that. Of interest here, because most of you are doing corporate law, commercial law, you're involved in mergers and acquisitions. So you'll always come across this question of pensions in any of those transactions. And how you deal with it depends on the extent to which you understand how pensions lay out, for you to give a comprehensive advice to a client when dealing with a corporate transaction, a corporate merger, and those kind of issues. So Pension, from a state point of view, is a social question with some constitutional obligations on the state to provide to the people. The right to social security in Article 43 comes into play under this view. And in a number of recent decisions, for example, in India, pension is understood as a constitutional right. From an economic point of view, pension can be viewed as an area of investment law. And there are many laws regulating pension investments under capital markets, capital markets laws and pension laws. And I do know many of our colleagues in this market who practice in this area, and they'll always find disputes arising from investments of pension funds. And you need to understand investment laws for you to be able to deal with some of these disputes and also properly advise your clients. Of course, under employment law, the existence of occupational schemes in this market is a function of an employment contract. Some statutes require employers to set pension plans for employees. For example, if you look at most of the parastatal acts, those acts which establish various parastatals in this country, there's always a clause somewhere which requires that the board of directors will establish a pension scheme for the workers. Some institutions have set up individual pension plans where members join under a form of a contract which you sign, and then you start saving for your retirement years. And pension has been argued to be a deferred remuneration in several other countries like Canadian Supreme Court, the UK Supreme Court, even South Africa. Supreme Courts, they have decided that we need to view pensions as a deferred remuneration. And once you make that kind of a decision, then you need to know how to handle pensions when disputes arise. Can an employer, for example, reduce your benefits when you are retiring just because it thinks it was a grant to you or some kind of charity that it was doing to you? And of course, once you make a decision that pension is a deferred pay, then of course, a right accrues to it, it vests in you, and it has to be treated to you as your own personal property, which cannot be reduced or interfered with by any other person. Of course, I've mentioned under family law in many jurisdictions, pension accrued during marriage forms part of matrimonial property. And in most of these other countries, in more Western countries, Europe, even South Africa, they have a legislation which clearly defines that pensions accrued during a marriage constitutes part of matrimonial property. Can we include pension as part of matrimonial property under our legislation? Can it be more clearer, or can the jurisprudence out of the courts while addressing this question make that clearer than what it is at the moment? So pension schemes in Kenya, unless established under a written law, as I indicated earlier, are established as irrevocable trusts. So trust law doctrines apply, but always limited by statute, even as you apply them, because we have the Retirement Benefits Act, which provides that pension schemes should be trusts. But of course, trust law, as we understand it from common law doctrines, is limited by various provisions of the statute, even as you apply it. Judicial laws apply. Trustees hold assets on behalf of members and beneficiaries, which, of course, with wide powers and discretion. If you look at the mandate trustees have under the Kenyan Retirement Benefits Act and the various regulations, various guidelines which have been issued by RBA, it's an enormous responsibility. But nonetheless, therefore, you need to see all those duties as fiduciary obligations which are vested upon trustees, even as they carry out their duties from time to time. So pension schemes have different legal forms, and depending on which country, we have institutional types, an independent pension fund with some legal personality. In Kenya here, I can only give an example of NSSF, which is an independent body with the corporate status, with an internal governance board and fiduciary duties to members. And many other countries have adopted this. Examples given like Denmark, Japan, Poland, Netherlands, South Africa. In South Africa, for example, once a pension scheme is licensed by the regulator, it assumes corporate status. Probably we need to think through whether that's a better option that we need to adopt in this market. And it has a single governing board, which often is appointed by the founders. In this case, for example, in Kenya, it's appointed by the stakeholders in the employment market and also government. The other form is that of a trust, like which we have adopted largely in this market. Pension schemes are basically trusts, and they have trustees have a legal ownership, while the members have the beneficial ownership, and in most countries which were colonized by the British. The trustees have the duty to run and manage those pension funds for the sole interest of the members. And we see many of those examples in Kenya, in UK, Australia, Uganda, Ireland, countries which have the English tradition. We have another category, the contractual type, and some countries have purely adopted this mode, where pension funds are a segregated pool of funds which is just put together without a legal personality, and they're governed by a separate body, which is, for example, banks, insurance companies, even pension fund management companies. Currently, I'm doing some work for the government of Mozambique, and this is a mode that they have adopted. Other examples are Angola, Nigeria, which amended to this format not many years ago, and Portugal. So we have, anywhere you can go, find one of these types of legal forms of a pension fund. And that is critical for those who want to practice this area of law across the border to many other countries. Now, there are also pension types, and there are largely two. One is occupational pensions, which sometimes we call closed funds, in the sense that they are limited to the employer and the employees of that organization, so that no any other person can participate in it. They're established by the employers, sometimes with workers' unions, to provide retirement income to the employees. They are not for-profit entities. They do not establish these pension funds. Employers don't establish these pension funds for purposes of doing some commercial business. They are basically not-for-profit organizations. They offer defined benefit or defined benefits or hybrid pension benefits. The common ones, of course, in this market is defined contribution. We used to have many defined benefit schemes, but they are slowly winding up at the moment. And there are very few hybrid schemes also. The second type is the contractual pension funds, sometimes referred to as open pension plans. These are established by financial organizations for commercial purposes. That's the difference between schemes and the contractual type of pension funds. Any person can join on a contractual basis, offering DC benefits. They don't offer DB benefits, and members choose to provide. Members choose the provider. You can choose from the market the provider you think is going to be more favorable to you, and you continue contributing there. And when you retire, of course, as per the contract, you'll access your benefits. In some cases, you'll find the employer asking you to choose where you want the money to be sent to. If you do not choose the providers, in some cases, employer may select the provider for you. And I've seen some of those examples in Australia and New Zealand. Now, in Kenya, we basically have a large category of the system is categorized into three, what you call the zero pillar, the first pillar, and the second pillar. And the asset base in Kenya at the moment is about 1.7 trillion Kenya shillings worth of pension assets. The zero pillar is like, of course, what we call the Inua Jamii state-funded schemes to alleviate poverty for a population which qualifies as exposed to poverty by the area chief, and it does provide basic income, and it runs under the ministry in charge of social protection. The first pillar is the monetary scheme, which is basically NSSF. This is mandatory to all the workers. And of course, we do know that the NSF Act was, the previous one was replaced by the 2013 legislation, which is now in force. And it does introduce an element of voluntary contribution to cater for the self-employed. So NSSF is mandatory to all the workers. Unless you are specifically excluded, you have to participate in NSSF as an employee. The self-employed and informal sector only participate on a voluntary basis if they so wish. The second pillar, which is basically the majority of pension funds in this market, they are mainly employer-based and contributory, except for the public sector schemes and county government schemes, which are currently under reform. This also includes umbrella funds, which is basically where employers come together and set up one pension scheme for all of them, rather than having each employer having their own pension scheme. And also this category includes individual plans, basically where you go to an insurer, buy your retirement plan, and you continue contributing. And many other individual schemes which have been registered by RBA, you can also move there and sign a contract and start contributing in a manner that you agree with the provider. So if you want to basically understand the pension system in Kenya, it is every pension scheme will either fall in one of those three that I've just described. Just to summarize quickly on the objective of pension schemes globally, pension schemes serve three major purposes. One is consumption smoothing. That is, you want to consume a portion of your income now without completing it now, and save a little of it in a pension fund, which you will need later as your quality of into retirement years. So you basically postpone some consumption, and the pension policies aim at enabling you smooth your consumption from active years of employment to retirement years. The second objective is poverty relief. Voluntary retirement savings may be insufficient to deal with your exposure in retirement. And so government cash transfers become handy to support those who are exposed to poverty. And sometimes these programs are universal or means tested. The example we have in this market is what I said earlier, which is Zero Pillar, the cash transfer to the elderly in this country. And the aim there, the objective there is to alleviate poverty. The third option, the third objective is capital mobilization. It's usually what we call secondary objective. It's not the core purpose for which we establish a pension system, but for reason of putting our money across the globe, for the major countries with the major pension funds, the base as of 2023 is $48 trillion US, a colossal amount of money, which of course, once channeled properly, can do a lot of economic activities in any one country. So let's now move to the area that you will be most interested in, and that is the areas of practice. Number one, an area which often is not well understood, and yet it is very vibrant to those who are in this area of practice, is pension consultancy. Since the 1980s, countries are reforming their pension systems to address the question of sustainability and affordability of pension programs which they provide to their populations because of the aging issue, and also market underperformance and some of the fiscal deficits which governments face from time to time because of the economic changes. And poverty among the elderly has also become a constitutional issue in modern constitutions, and therefore states are obligated to provide pensions to the elderly. And therefore, this reform has been triggered by some of these new developments. The issue of co-sharing the financial burden of providing pensions has also led a number of countries into reforming. and also the introduction of regulation and supervision of this sector, which previously had never been regulated. Among, for example, banks, insurance companies, capital markets, the pension sector is the latest in that queue in as far as regulation and supervision is concerned across the globe. And because of that need and the role they play in the socioeconomic environment of any given country, there is always a need as a reason which requires regulation and supervision. There are other pension consultancies which require lawyers in as far as pension is concerned. And these reforms require a comprehensive legal and institutional reforms in any one country. I've been involved in a few countries in Africa and in Asia. So lawyers will always be part of the larger team involved in reforming a pension system in any one country. The skills required are actuaries, you need financial and pension lawyers, people with expertise in investments, pension economists, and all those. They will always form a formidable team towards getting some work to do for states, governments, and reform a whole pension system in that given country. Of course, you'll ask, how do you enter into this market? Because most of these projects of reforms across the globe are either financed by the World Bank or IMF or regional financial institutions like Asian Development Bank, African Development Bank, and even governments floating a tender openly for international bidders. It may be important that you form a team for purposes of bidding for some of these international tenders. Of course, once you've tendered, you enter into a record of one of those persons who can be sought after by either those countries or by the World Bank or regional financial institutions for purposes of rendering some of these services to many other countries. Of course, at the local scene, we have work to do in as far as pensions is concerned. As lawyers, we have an obligation to our corporate clients or institutions giving legal advice on the establishment and the management of pension funds. Companies, from time to time, they're establishing work-based or individual pension plans, and lawyers will always be sought to advise how to establish a pension fund, how to assist them put the institutional framework amidst the complex pension laws that exist. So you need to have a good grip of the Retirement Benefits Act and the various subsidiary legislation under that act. You need to understand employment contracts and labor laws, tax laws as applicable to pension funds. And of course, trust law is critical as the fundamental law which applies to pension schemes in this country. You need to appreciate various other acts which have something to say about pensions. For example, the Children's Act when it comes to attachment of benefits. Usually outlawed in the Retirement Benefits Act, but the Children's Act does allow that pensions can be attached through a court order to support a child who some pensioner has neglected. We also have the duty to draft various documents which inform a pension scheme, and those are the trustees and rules, service level agreements between trustees and the various service providers, fund management agreement, custody agreement. You have administrators agreements, and there are also requirements under the Act where trustees are supposed to establish various policies, governance policies required under the RBA guidelines, and it's quite amount of work to do for a lawyer who is practicing in this area. And then deeds of amendments, many other things which you may be called upon by your client to do in as far as a pension fund is concerned. Then, of course, you'll need to have the trustee registered or incorporated as a trust, Trustees Perpetual Succession Act, and of course, assisting the client to comply with the RBA, especially on areas of benefit payments, because usually that's what the disputes are. You'll always find many people coming forth for payments of benefits, especially once a member's died. And you need to assist the trustees to identify who should actually be paid. And these are some of the areas that you could be involved in as a corporate lawyer, providing pension services to, pension legal advice to your client. A critical area which also we have been involved in, myself and our law firm, is legal advice, conversions, and DB risking. The risk of the employer failing to sustain its pension promise to the end is real all the time. Some employers may run into financial difficulties and they are unable to sustain their pension promise to the workers. So it becomes a pension legal question. It also becomes an employment question, whether you can actually fault or fail to meet your obligation as an employer to the employee when it comes to the DB pension promise. So, and this can happen because of significant funding level volatility. It could be because of the sponsor insolvencies and a range of regulatory developments which may arise, triggering a need for conversions from a DB scheme to a defined contribution scheme, or transferring the risk to the insurance company. So most employers therefore have opted to do a number of things to de-risk a DB scheme. They can close the DB scheme and exclude new members from participating in it. They can convert the DB scheme into a DC scheme. They can transfer the DB benefits from in-house to an insurance company. Now, of course, as they make all these decisions, lawyers need to advise whether you are paying attention closely to the obligations that are in the deed, the trust deed and rules, the employment contract that you have with those workers, and also the Retirement Benefits Act and the various guidelines issued by the regulator. So you may be called upon because of this to draft new trust deeds. You may be required to do amendments to the current trust deeds. You may be called upon to issue sufficient notices to employees to make sure that you comply with the employment obligations. And this has been an area of many legal disputes at the RBA Appeals Tribunal. I think all the tribunal cases which have been there, most of them have been around this question of converting from DB to DC or amending the deed to manage your DB liabilities as an employer. And there have been very interesting decisions from the tribunal. Just trying to see what's happening with my system. Yes, we are in progress, even as the slides have refused to move. Yeah, they have come now. Thanks. Another obligation, another area of practice is amending deeds, and this is done every other day by those lawyers who practice in this area. We do get many deeds from pension funds, requiring us to amend. And are you hearing me? Are you?
Yes.
Thank you so much. Wasn't too sure because somebody was calling me from just to communicate to me about this. Lawyers are engaged regularly to amend deeds, and the deeds must comply with the statute, and they must be approved by RBA. Of course, not amend the deed if it does invalidate members' benefits which have accrued. You cannot amend a deed which is going to affect the right of a creditor of a pension fund, and you cannot or an amendment will not be deemed as an amendment until it is approved by the authority. Some cases have arisen out of this on the question, when was the amendment done? And because sometimes trustees make a resolution to amend their deeds and then they do not have it approved by RBA, and they start effecting it in their operations, and an issue arises as to whether it was really valid or not, and that has caused some costs to some schemes for failure to comply with this obligation to properly amend their deeds. I mentioned earlier about mergers and acquisitions, often an area neglected by corporate lawyers, especially if they are not interested or introduced to pension law. Acquisitions and mergers can have a complicated pensions element, especially DB pension schemes. Employment terms and covenants relating to pensions need to be discussed during the merger and or acquisition. Because if you don't do so, the buyer or the company acquiring the other may actually go along with some of the obligations they didn't know. So a number of things need to happen. The pension issue will be part of the terms of merger and acquisition during the due diligence work. Actual evaluations or an audit of the schemes will have to be carried out to ascertain the liabilities which the buyer is likely to take on board and how that will be negotiated between the two companies. The reasonable expectation of pension members will have to be protected so that the deed and see whether if the new company which is coming on board is having a different view about pension plans, especially on financial issues, and protect the rights of the scheme creditors. Rights should not be diminished. And of course, RBA will have a right to have a final say whether they agree with the arrangement or not, in as far as pension issues are concerned. And you can always work with pension lawyers to make sure that this aspect is properly taken care of. Just to add a little on this, there are a few things that are critical in my view, which any lawyer who is involved in a merger or acquisition needs to pay attention to if the company which is being acquired is having a pension fund. You need some sufficient due diligence for you to be able to know the extent of the liability. Underfunded pensions in a corporate transaction is a matter of attention to any other transaction lawyer in this business. A lawyer needs to ensure that the purchaser does not inherit the seller's pension liabilities. Due diligence to focus on the careful examination of the scheme rules to clearly determine the underlying pension guarantees. And the lawyer who is involved in this advice or this transaction need to appreciate the funding position of the accrued benefits, the cost of providing the future benefits, and whether the scheme is in compliance with the provisions of the Act, among many other requirements under the Retirement Benefits Act. So for you to give a comprehensive view and guidance to your client on a merger and acquisition, especially where a pension is involved with one of those companies, then you need to have a good grip of how pension law works out. Of course, pension funds get terminated and they get wound up, and they could be partially terminated or fully wound up. And sometimes the winding up can be done voluntarily or by the court. Court order termination and winding up is premised on the scheme and soundness in terms of finance, or if there's low funding, if it has failed to comply with particular remedial actions recommended by RBA, and discovery of false information during registration of that pension fund. It will also be found to be a case of winding up if it's in breach, especially massive breach of the Retirement Benefits Act. So these are aspects which and advise the pension funds from time to time. The question of sponsor insolvency: if the sponsor gets insolvent, you need to give legal advice to preserve member rights in the case of a sponsor insolvency. Lawyers over liquidation services. I know RBA has appointed few lawyers to carry out the liquidation services to some pension schemes, and also over legal advice on the process to trustees on how to progress liquidation issues to mitigate the legal risks which may arise from the members if the process did not comply with the law. Of course, some of you who are practicing in climate change law and environmental laws, there's an aspect of pensions which is now emerging. While the Act or investment guidelines under the Retirement Benefits Act are silent on environmental, social, and governance investing, the guidelines which have been issued by RBA recommend to trustees to adopt socially responsible investing. And trustees need to consider ESG as a factor which should inform them when they're carrying out investments of pension funds. And lawyers in other jurisdictions are taking the lead in advising trustees on how to comply with the many requirements of environmental, social, and governance issues when it comes to investment. They do review the investment policies to ensure that they comply with the internationally agreed governance, environment, and social issues. The scope of trustee powers when complying with this expanded scope of pension asset management, they are always advised by lawyers to make sure that they are complying because they need to report from time to time. A good example is, of course, the UK Pension Lawyers Association, which are always taking the lead when it comes to ESG investing by pension funds in UK. And something which I think we can also start helping our pension funds in this market, which gradually and slowly are considering this issue when it comes to investments of pension assets. The latest UK Pension Court, Supreme Court decision stated that schemes may also take purely non-financial considerations into account, provided that doing so could not involve risk of financial detriment to the scheme, and where they have good reason to think that the scheme members would support their decisions. So, in other words, because previously we used to consider financial considerations when making investment decisions, but now we are moving away from that slowly. Not that we do away with it, but we combine it together with the non-financial considerations, which basically includes ESG when making investment decisions of pension assets. This is not a big issue in Kenya at the moment, but I think from my understanding of how we are moving, this is something which will come into one of the factors to be put into the investment guidelines under RBA. And then lawyers will have to be sought for purposes of guiding pension trustees on how to comply with the ESG investing. As a number of lawyers are involved in advising trustees on how to comply with the Data Protection Act to make sure that the data of members are well protected in accordance with the provisions of the Data Protection Act. And of course, the Unclaimed Financial Assets Act, which requires reporting on unclaimed assets. I do know some organizations which have been penalized for failure to report and submit some of the unclaimed assets, something which you can help your client to avoid from time to time by advising them to comply with the Unclaimed Financial Assets Act 2011. Again, the question I raised earlier regarding matrimonial property, Section 6, which defines what matrimonial property is. The question here is whether pension assets which have been accrued during marriage or pension funds, pension benefits, could constitute matrimonial property. Which was recently decided in Mombasa, funds in a bank could be declared matrimonial property, depending on the evidence provided during the hearing. The question is whether pension acquired during marriage could be treated the same as matrimonial property. So family lawyers need to start thinking through whether, when dealing with the division of property in the event of dissolution of marriage, this is a factor to be considered. In one case, one of the parties in a dispute submitted his pension as part of his income, because that may be a requirement when you need to disclose how much money each of the parties have in a hearing, and he actually included this pension income as part to prove his income. So this question has been really settled in many other countries because they have come up with statutes which clearly state matrimonial property includes pension which has been accrued during marriage. Whether this is a matter we need to start thinking about or try and see how the courts will resolve it, I think it will be an interesting area of practice for those of us who are practicing in family law matters. I think I've spoken about employment, except for social pensions, which are the cash transfers of government and individual plans. Other pension schemes are basically based on employment. And as an employee benefit, a number of lawyers have filed pension disputes before the Employment and Labor Relations Court. The Supreme Court has ruled that pension disputes are not included in the definition of a trade dispute. And hence, the Employment and Labor Relations Court does not have jurisdiction to entertain pension disputes. The Constitution under Article 165 restricts the High Court from exercising jurisdiction on matters dealt with under a specialized mechanism like RBA tribunal or any other tribunal. So the question is whether does that therefore mean pensions are completely separated from employment law? The question is no. The answer is no. The pension promise is always embedded in the employment contract or a policy. So in South Africa and UK, courts have resolved that pension is part of remuneration, and therefore you may not completely separate it from employment issues. Both of them intersect at some point, and therefore we need to, when you are practicing employment law and there are matters of pensions which arise, you need to know how they intersect and where one ends and the other one starts for purposes of giving proper advice. Let me not say much on that question, but it's become an area of interest. There's a whole large text of law which is employment and pensions, written by a UK lawyer, and very interesting on how both employment and pension law intersects. And we just need to appreciate, when practicing employment law, how we also give advice to our clients regarding matters pension, which are probably encompassed within the employment contract. And dispute resolution, which I think most lawyers have been practicing in as far as pensions is concerned. All pension trust deeds contain a dispute resolution clause, often never used by members or trustees. They always like going straight to RBA to resolve their issues. I want to encourage lawyers who are practicing in alternative disputes resolutions to try and access a lot of business on pension disputes, which could be resolved through alternative dispute resolutions. And those clauses are always provided for in trust deeds and rules. However, RBA has provided, the Child Benefits Act has provided powers to RBA to determine a complaint filed by an aggrieved party to the Chief Executive Officer. And if you are not too happy with the decision of the Chief Executive Officer, you can then file an appeal before the Retirement Benefits Appeals Tribunal, whose decision is final, and you can only go to the High Court on a judicial review of that decision. The Supreme Court has insisted that pension disputes for the first instance must be presented before the Retirement Benefits Authority Chief Executive Officer for determination. A number of lawyers do represent parties before the RBA tribunal, and therefore I will encourage that litigation lawyers and those involved in alternative disputes, there's a whole range of work around dispute resolution in pensions. So, and one of you want to be a pension lawyer? I do know recently one of my associates here has just came from the University of Nairobi, and they have started teaching elementary aspects of retirement benefits law. But it's fairly basic, but it's a good start. But as a lawyer, you need to have studied pension. I mean, you need not have studied pension or social security law. Our universities have not been teaching this area, and few other universities across the globe teach pension law as a subject. And therefore, it's enough to know where to find your law and know how to interpret it, which is the training of any other lawyer. So a lot of patience is required when you want to build your career around pension law practice, because it does cut across a number of disciplines. In Kenya, as we have seen, you need to have a good understanding of trust law and some basic understanding on finance. You need to have some understanding on employment law, which, because pension is deemed to be part of employment benefits, you need to understand the investment environment. Pension funds are invested daily, and legal issues always arise around this subject. And for those who are interested to go beyond Kenya in practicing this area, especially giving consultancy, you need to have a global trend. You need to know a global trend of pension reforms and systems across the globe. That's for international work, because you will meet many consultants who have a good understanding of what's happening across the globe, and the countries expect you to understand their local pension systems for you to be able to give them good local advice. For young lawyers interested, if the opportunity arises to work with an experienced lawyer, I think this will be a good start for you to build, and you'll find it easier probably, and probably enjoyable. There's a lot of reading of documents, which sometimes are very boring, but I encourage lawyers to pay attention to this if you want to build your interest in this area of law. Of course, if you have some money, just attend workshops which have been organized by pension experts. They give you a good picture, well-rounded picture on this question of pensions. So as I conclude, pension law is an emerging area of law. The structure and arrangement of a pension scheme varies from one jurisdiction to another. Pension law intersects through many other laws, as we have briefly seen, and a lot of pension practice is non-litigious, but sometimes huge pension disputes do arise, involving billions of shillings before the RBA or the RBA tribunal. So the pension sector is continuously growing in Kenya, and hence creating an opportunity for all of us to practice. And there are many areas we can now see which are available to us for purposes of practicing pension law in this market and beyond. For those interested in international consultancy, is a large and is a large area of practice, and does require a good team of all disciplines that are necessary for purposes of providing good consultant services to either country or some organization. And it may require that you team up with actuaries, pension economists, pension lawyers, etc. So friends, for this rush through of this presentation, I want to welcome you aboard. Those who are interested in pension law, we can always engage and discuss further on this subject. Retirement benefits have a key role in individuals' well-being by providing both actual financial support and psychological confidence about a financially secure future. Thank you so much. I want to return this back to you. Back to you.
Thank you so much, Mr. Nyakundi. That was very insightful, especially the bit where you mentioned about having to consider pension as something to be subjected to succession. And I am sure most of the advocates have learned a lot from this session. I'm not, let me see if the chair is on call so that she can also give her closing remarks. Chair, are you there? I think the chair has dropped off. So before we close the session, perhaps if anyone has a question, they can raise their hand up and we can go in an orderly manner before we just close this webinar. I can see a comment on whether we can have the slides, Mr. Nyakundi.
Yes, I'll probably send it to you, then you distribute.
Okay, thank you so much. Any other question? There seems, oh, okay, we have one. There we go. Mr. I'm not sure if it's Mr. or Miss Kitunka. Please go ahead.
Thank you so much. I want to ask, if a person retires after working for an institution for, let's say, 23 years, and then joins another institution, and then dies in that institution, is he entitled for payment of retirement benefits in both institutions from both employers?
Did you say retires or dies in the second institution?
The first time he retires from the
Yes.
first employer, then is employed by another employer, then he deceases in the second employer, but the second employer pays the benefits, then the first employer refuses to pay. Is he entitled to payment by both institutions?
Yes, you are entitled to your accrued benefits from both organizations.
Okay.
The best thing to do is when you change employment from one employer to the other, it's always advisable that you transfer your accrued benefits to the new employer so that you continue building it up in your new employer. However, the challenge may arise if you are dealing with government, if you have been working in central government or civil servant, where what we call the vesting right is 50 years and it's an unfunded scheme. So you move on to a new employer, which is a work-based pension scheme. But having your services transferred, then of course you are likely to lose the pensions accrued in the civil service. But if it's from private employer to the other, where you have been contributing, you have a right of your pensions from every employer where you have worked.
Could you kindly repeat about the government employer?
If you have been a civil servant,
Mm-hmm.
and you get a better job in the private sector, and you resign from government and move on to the private sector employment, you are likely to lose all your years or pensions accrued in the civil service. The only way that you can access that benefit is if in the course of living civil service, there's a procedure which is provided on how you can preserve your benefits there. Sometimes they can allow it, sometimes they don't, especially if they think you are simply moving to a greener pasture in private sector. And therefore, you run the risk to lose out everything else that you had accrued in the civil service pension scheme. So in those circumstances, yes, because under the Pensions Act, you vest a benefit after attaining 50 years. So, which is basically the early retirement date. And therefore, if you moved from civil service, probably you shall not have attained 50 years to accrue a benefit, and therefore you are likely to lose it. Yeah. You get the point now?
Yes, and if you've attained 50 years?
Upon clocking 50 years as a civil servant, the benefit vests in you. You can actually leave at 50 years from civil service and start accessing your pension. If you get a job elsewhere in the private sector, of course, you can start accumulating again up to the retirement date in that private sector, and then you get another benefit from that organization.
Okay, I've understood. Thank you very much. That was very helpful.
Yep. Any other?
Thank you, Kichwa. I can see we have more hands up. Wangila Waliaula.
Thank you again for that very presentation. Seniors, as you correctly said, that this is an emerging area that is not taught in most of these universities in the country. We will be very happy if probably seniors like yourself could collaborate with other people to probably come up with some form of curriculum that can be able to guide those who are interested in practicing to join in this area of practice, because as you might be aware that some of us we might get instruction in this area with very little or minimal knowledge on the same, and we end up probably learning on the job. So we'll really appreciate that if in future, or if you'll be able to get and decide to do some trainings on the area, we would be very interested to actually join and learn more about the area. Otherwise, again, thank you very much, Senior, for the presentation. Thank you.
Much appreciated. That is true. Some years when I was working at RBA, writing up all the subsidiary legislation under the Retirement Benefits Act, which most of them are currently involved. We were involved with this subject. We had a meeting with them, and I thought they could start. It took many years. Not attention to the content of the curriculum, but as I said, my associates who has gone through that program at the university, it's fairly. I've been involved in the national pensions policy for this country, which I've just finished, to work with me. That's when I realized that when we go through the university is quite. Good thing about it is it gives you an appetite, some fundamental basics, then to address this issue, probably to have more webinars, more seminars, workshops, just to teach ourselves, for those who are interested on this area of law, and you'll start building capacity from that point moving forward. Even as you get the instructions, you then start practicing it more. Then you get to know how to apply some of the knowledge you acquire in the webinars, in dispensing instructions you get from your various clients. Yes, so I agree with you. That's a good point.
Thank you, Senior and Wangila, for that. Makena, before we go back to Pitunka. Makena? Okay. Maybe Makena has dropped off, but we have a comment from Quincy Kipto in the comment section. Makena, are you back? Okay. Comment from Quincy. May we hear the speaker's comments about the status of pension attributable to civil servants above 50 years? I think this was answered, isn't it? I'm not sure though. Who were dismissed from the service prior to the Obadiah versus Attorney General decision.
I didn't hear very well. If you can repeat it again.
May we hear the speaker's comments about the status of pension attributable to civil servants above 50 years who were dismissed from service prior to the Obadiah versus Attorney General decision?
I'm not too sure. I was aware of that, of the people who are dismissed, but the principle under the Pensions Act is fairly simple when it comes to your pension rights. Until not too many years ago, under the Pensions Act, which applies to civil service pension, pension was a privilege in that act. It was, therefore you can lose it. You could lose it at any one given time. But that a right, and pension then vests in a member at the age of 50. So if you work for years in civil service, it's supposed to accrue to age 50. And then it is payable to you because it's what we call a pension type of scheme. So if, for example, at 50 or at 51, before you retire, retirement being 60, before you retire at 60, then you are sacked. You could have a case against the government, a pension which was already accrued at age 50. So I wasn't too sure of the facts of this matter. Probably I may wish to read it just to understand what was the issue. The cases that I'm familiar with are those of the former Chief Justice, Justice Coker, who filed suit for being paid pensions using a wrong file. And it became a trigger of many issues for the other judicial officers and who were, you see salary service must be gazetted. So he assumed or adopted a salary which was not gazetted. And as far as the Director of Pensions is concerned, he will pay pensions as per the gazettement. So the question of pensions, that was the bigger issue during the Coker case. And but of course, the judiciary, in a way, agreed with Justice Coker that it should be based on the salary he was earning at the time he left, not the gazetted salary not reviewed for several years back. And that case triggered quite a bit of financial implication on government, but nonetheless, they were all paid. So if you are above 50, the assumption is pension has vested and you're entitled to it, unless there are some other factors for me to be able to give a better advice on this matter.
Thank you so much
proceed.
for that. Thank you so much for your feedback, for the questions we've received, the engagement throughout the whole webinar. I can see we do not have any other hand. I'm not sure if Kitunka, you have a second question or this was the initial, because I can see your hand is up. I'm not sure you want to speak again.
I forgot to remove the hand, but now I have another question just to ask. Is it possible for a person to transfer services when they are over 50 years, or you just retire automatically?
To transfer, if you transfer benefits after 50 years?
Yes. Yes, is it possible to transfer after 50 years, or you just retire automatically and start working elsewhere?
From which organization? From a private company
From
to another?
public or private to private. Yes, from government to private.
If there's no transfer,
It's breaking, I can't hear.
and for a simple reason. You are not hearing me?
Yeah, repeat kindly. Now I can hear.
Yes. Now hear me. Okay, thanks. You will not be allowed to transfer your accrued benefits from the civil service pension fund to other private pension fund. For a simple reason. The simple reason is
Na ndio hiyo
in civil service.
wakati insurance hapo iliruka ndani ikakuwa kuna mambo.
Hearing me?
Someone is making noise.
Are you now?
Okay. Now I can.
Okay. That's all right. The reason why you can't transfer from the civil service to the private pension fund is because the civil service scheme is not a funded scheme. It doesn't have assets. And the government pays pensions from tax revenues at the time people are retiring. So if, for example, you have worked in civil service for 15 years and you want to transfer and then you want to be paid, you will not be paid. There's no transfer. There's no money to transfer. So that's why I said earlier that for you to preserve your pensions in civil service, there's a procedure you need to comply with, which is to have your service transferred to the new organization if the government agrees. In most cases, it will not if that transfer is not intended to advance the cause of government or government interest. If it's for private interest, probably they will not, and your accrued benefit. But if they approve it, then your pension will be preserved within the civil service until you attain retirement. Then you go back to the civil service to get your check, together with the other check you may have accrued in the private sector pension fund. But there's no transfer from civil service pension, civil service pension scheme to the private sector pension scheme. We have tried to raise this issue with as a policy issue, but it's yet to be determined.
Okay, understood. Thank you very much.
Thank you so much, everyone, for engaging the speaker and the speaker for the insights you've given us on this cold afternoon. Would like to thank you on behalf of LSK Nairobi branch, the chair, and the entire council. Unfortunately, the chair had to get into another meeting. So if there's no other question, I would like us to come to a close, and thank you for being with us this afternoon, and look out for the next session of the opportunities in pension practice through our socials and weekly newsletter. Mr. Nyakundi, do you have any closing remarks?
Much appreciated. Thank you so much for listening. And we hope to engage again later when the opportunity arises.
Thank you so much, and enjoy your afternoon.
Thank you so much.